You used, when I asked you, or when a number of us asked you about making some of the currently the executive branch cabinet level agencies multi-member agencies, you resorted to the functionality of the current agencies such as Commerce as precluding that, or at least as being a basis for not doing that. Now, moving the other direction, could you functionally, you say that from a functional standpoint, the FTC is not an executive branch agency, and you listed some of its functions. Could Congress convert the FTC to a single member head with the same protections? Because it engaged in discharging the exact same functions.
No, under this court's precedent in CLA law.
Could they, under the logic of your argument?
No, we accept CLA law as not only the law of the land, but as being correct.
So
we embrace its reasoning.
What's the limitation? Your argument was functionality before, not necessarily precedent. And I'm interested in why would the FTC functionally be any different as a single member head than it is as a multi-member agency?
It is because CLA law is correct, not just because it's precedent, but because it's correct to hold that there is a particular danger to individual liberty that is posed by the single director, highly anomalous circumstance that had no foothold in history and tradition, and that vested a massive quantum of power in one person who was not directly accountable to the president.
I don't understand why that's any different from a multi-member agency.
For all the reasons, Justice Thomas, that this court explicated in CLA law itself, and in particular in parts 3C1 and 3C2 of the decision, where the court talked about basically two categories of considerations. One is the foothold in history and tradition, and the second is whether the configuration of the agency poses a problem for structural separation of powers principles. And in both of those, the court explained, and elsewhere throughout the opinion, the implications for individual liberty of taking massive amounts of governmental power and putting them in the hands of one person who's not accountable to the president, as opposed to where you have the multi-member structure. As a practical matter, there needs to be consensus, there needs to be deliberation, there's a safety valve in terms of dissenting opinions can be issued, and that can provide an alert to the public that something is going on. So there's a whole variety of reasons why single-member agencies have been distinguished from multi-member commissions, and we think that precedent is correct and should be adhered to. And on that point, Justice Thomas, I guess I would say one more thing, and that is I think it is a big difference between our position and the position of the petitioners, that we are asking the court to adhere to all of its precedents and to give effect to the collective wisdom and experience of all three branches of government. On the other hand, petitioners are asking you to abandon precedent after precedent after precedent. A lot of precedents would go south if their constitutional theory is correct, and a whole lot of history and dozens of institutions that have been around for a long time, that have withstood the test of time, that embody a distillation of human wisdom and experience, all of those would go south.